Now you can watch WHPR TV 33 on Fire Stick. Catch all of your favorites. Stay informed. Don't miss a minute of your favorite talk shows. Call, text, tweet, post. WHPR TV 33 is worldwide on Fire Stick. For more information, go to FirestickTVNetwork.com or call us at 313-868-6612. WHPR TV 33, a Watkins Broadcasting Company.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers. With Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Good morning. Welcome to Law Power Hour. It's a gorgeous day in Detroit. It's going to be about 61. A lot of folks are going to be getting out from now well into the fall, having a good time. And many of them are going to be going out and doing things we call recreational activities, whether it's playing golf, going on an ATV, hiking, fishing, camping. All these activities are covered under the Recreational Land Use Act of Michigan. It's called RUL. Now, the Recreational Land Use Act of Michigan was enacted in the early 50s. There were about 20 states that had it at that time. Now more than 40 states have recreational land use acts that specifically identify and apply to activities by individuals while they're engaged in having fun, being outside, enjoying themselves, whether they're at a picnic in the park, whether they're at a park where there's slides and the kids are using the slides, at a swimming pool, at the lake, or even walking the shoreline. And the reason that I wanted to have this show today is because it's a very difficult subject to digest. And I'm not saying that to you listeners because you're not going to understand it, but it's even hard for lawyers to digest. And I'm going to give you some specific examples of what the Michigan Supreme Court has done in this area before we talk about the status of individuals when they're on property. Now, today, we have laws, as I told you, called recreational land use, that do not hold the owners of property responsible for injuries unless there's gross negligence, in other words, willful and wanton neglect on the property. Just 1 year ago, the Michigan Supreme Court decided a very, very important case involving a little girl who was building sandcastles and skipping stones in the water along Lake Michigan. Well, the night before, some folks had a beach party. And when they had the beach party, they decided to have a bonfire. And after the bonfire, they buried all the coals and all the rocks in the sand. Well, as she was walking along, she tripped and fell. And she tripped and fell on the rocks that had been covered, that had been used for the fire. They were still hot, and she was burned. So her parents filed a lawsuit against the owners of the property. And under the Recreational Land Use Act, she wasn't allowed to recover because she was a trespasser. In other words, she did not have permission to be on the property. They were just walking along the beach without permission, and they couldn't sue the owners of the property. In this case, it was an inn along Lake Michigan. Now, the case went first to the circuit court. The circuit court ruled against her. Then it went to the Court of Appeals, and the Court of Appeals reasoned that because she was building sandcastles, she wasn't engaged in a recreational activity. But when it went to the Supreme Court last year, the Supreme Court overturned the Michigan Court of Appeals and held that the activity came under the umbrella of recreational land use, and consequently, there was no recovery. So here's the situation. You take your kids to the park, and they get injured in the park. You're not going to be able to sue unless there's gross negligence and you're using the park with permission that would make you a licensee, and their only responsibility at that point would be for an intentional and willful act. Now, this is really strange that the little girl couldn't sue. But another example of where a suit wasn't allowed was about 12 years ago when a lady was riding on an ATV, an all-terrain vehicle, in a mowed backyard, and she was injured. And the property that she was riding on came under the Recreational Land Use Act because that's where all-terrain vehicles went. However, she couldn't recover. And the reason she couldn't recover is because the property belonged to another person and it was part of a trail, and they had to establish first that she wasn't a trespasser, and secondly that she was permitted to be there, and there had to be knowledge of a dangerous situation because there was uneven terrain. In other words, the surfaces weren't level in the backyard, and it was a slippery slope, and she was injured on the slippery slope. Well, all of this may not make sense if you're spending your time in the city, but if you're like me and you go to Belle Isle in the summertime, you like to have picnics at Belle Isle, have a good time at Belle Isle, there's a risk-benefit because you can get injured there just like any other place. And it may not be your fault, but you may not be able to recover because of the Recreational Land Use Act and because of governmental immunity. So in order to make out a claim if you're injured in these situations, you have to understand exactly what's involved with respect to the claim. I'll take it one step further. Chene Park concerts. Now they're going to have this wonderful series of concerts at Chene Park this summer. And I always remember years ago of having a case involving Pine Knob where somebody snuck into Pine Knob and they were injured there and they couldn't sue because they didn't have a ticket to attend a concert at Pine Knob. And they were trespassers. They couldn't prove admission. If you can't prove admission, you can't recover. Sneaking on a golf course and not having permission to play on that golf course and getting injured on the golf course, you're a trespasser. And when you're a trespasser, you have no rights to recover unless somebody deliberately, intentionally, and willfully sets a trap for you to be injured. So this is what we're dealing with in Michigan today. It's a whole new series of rules and regulations as it relates to property. You know, to better understand the entire process, I think we should stop for a minute and take a look at the status of people on property. Put my water down there. There are different classes of people. There are invitees. In other words, when you're invited on the property of another, that's the highest standard of care that's owed to an invitee. For example, I'm going to the mall. I slip and fall in the mall. Well, I'm a business invitee. It's the highest standard of care that's owed to me. Can I sue the mall just because I slipped and fell? The answer is, under normal circumstances, no. However, there are exceptions to that. For example, if you slipped and fell in an area in the mall where the surface that you were walking on had been changed, let's say that they had been waxing the floors and there was a surplus of wax on the floor, and you weren't notified that the floors were slippery, you may have a claim. But if you knew they were slippery and you walked on them notwithstanding the fact that they were slippery, you ain't going to recover. So there you go. They have notice that they waxed the floor. You have notice that it was a slippery condition. You're not going to recover. But if they wax the floors and you have no notice that it's slippery, and all of a sudden you step on it, you slip, trip, or fall, you land on your spine, you hurt your back, you fracture a hip, you fracture your elbow, you may recover. But you have to give the owner of the property notice. In other words, if that incident occurs, don't leave the premises. Don't leave the premises without making out an incident report and letting the owner of the property know exactly what happened. I always remember the 4th of July one year when one of our clients was going into a grocery store to buy some watermelon. So as she picked watermelon up out of one of these big cardboard containers, she slipped and fell because there was some solution that was on the floor and it was sticky. She didn't see it when she went to get the watermelon out, but it was there. Her clothes got wet. Unfortunately, she got injured. And she told the owner of the grocery store about it. Well, they said they didn't do anything wrong. And then I learned from somebody in the grocery industry that they didn't put a liner in the cardboard box so that if any of the watermelons broke and there was a leak, it would be prevented, that leak would be prevented from causing any portion of the juices from the watermelon of dripping out or going out of the cardboard box onto the floor. So in that case, by giving notice and telling the owner of the store, the business invitee was protected. I give you that kind of graphic example because there isn't a week that goes by that someone doesn't call in to our law firm at Keller and Abedenka. We can be reached at 248-335-9266 and ask the question, can I make a claim because I slipped and fell? Last week a man called in. He wanted to make a claim because he was at an apartment building and he slipped and fell going down the stairs, and he said that there was no railing there. Well, the problem was real simple. What he didn't do is he didn't check to find out about the landlord's knowledge before he left. When he fell, he should have told the landlord or gone in and reported it in the office that there was no handrail. If he had reported that he had an injury and there was no handrail, the landlord would have been on notice. This is the biggest problem, business invitees and not giving notice. If you go into a fast food business and you get injured there, don't leave without reporting it and giving them notice. And if there's a defect and they don't have a reasonable time to clean up the defect, then you don't have a claim. These are all very important rules that you must follow. So we've got the business invitee going on somebody else's premises to transact business. That's where the highest responsibility lies for the owner of the property. To maintain the premises in a safe condition, to ensure that people aren't injured, and to give them notice of any dangerous conditions or to prevent dangerous conditions from existing that may cause injury. Now we've covered that aspect of it, of the business invitee. Now let's get to the next issue, the social invitee. You come to my house and you slip and fall on the steps in my house. Unless there's a defect in the premises, you're not going to have much of a chance of recovery. But if there's something wrong with the steps, and I didn't tell you, nor did I do anything to correct the condition, you may have a claim. Because I have an obligation to anyone who lawfully comes on the property to ensure that the property is safe. So these are just examples of what happens with invitees. The next level would be the licensee. I give you permission to come on my property, whether it's to hunt, to fish, to hike, to pick fruit at the orchard. I'm responsible if I have knowledge that there's an unreasonable risk of harm. An unreasonable risk of harm, and I don't tell you that there's an unreasonable risk of harm and you may be injured. Now I want you to start registering on all of these things, because there isn't a season that goes by that someone doesn't call and they'll have a question about this. We went out to the orchard, they'll call and say, and we were picking apples. The branch in the tree couldn't support our weight. We climbed up in the tree, fell off the branch, and got injured. I paid, this is the story, I paid a fee to pick the apples. So once I paid a fee, I was a licensee, and I had a right to be there to pick the apples, and I was injured only way I can recover is if there's notification of an unreasonable risk of injury. I don't know if it's making any sense to you, but that's a fact of life. I'm going fishing, and I pay a fee to go on the pier. And the pier is not sturdy, and I walk along the pier, and the boards break and I get injured. Can I sue? The answer is yes, if the owner of the pier fails to maintain the property in a safe condition. This gives you a right to bring a suit for your injuries. Now, let's go to the next level. I sneak on the pier and go fishing late at night after the pier is closed. And I'm out there with my spotlight fishing when nobody else is around. Or I go there early in the morning when it's fenced up and climb over the fence. Can I make a claim? More likely than not, you cannot make a claim because you're a trespasser. And when you're a trespasser, you have no rights. So these are the considerations that you have to look at in making a claim, because every time I read one of these decisions, I always see the same thing. Michigan Supreme Court protects lakefront landowners from liability in recent injury case where a person is injured on their property, walking along the shore, and there's a hazard there. Unless it's a trap to prevent people from walking on the shore, you're not going to have a chance of recovery. And this is the way it's been in Michigan for many, many years. It hasn't changed. It's not going to change. The Landowners Liability Act in Michigan that we're talking about also covers natural resources and environmental protection. It covers trails, outdoor recreation, fishing, hunting, picking of agricultural farm products at a farm or U-pick operations. The only claim that you have is if the person's injuries are caused by gross negligence. I'm going to take a break for a minute. When I come back, we're going to talk about the difference between negligence and gross negligence. I'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers. With Legal Lockbox, you can have access anytime, Anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Now you can watch WHPR TV 33 on Fire Stick. Catch all of your favorites. Stay informed. Don't miss a minute of your favorite talk shows. Call, text, tweet, post. WHPR TV 33 is worldwide on Fire Stick. For more information, go to FirestickTVNetwork.com or call us at 313-868-6612. WHPR TV 33, a Watkins Broadcasting Company.
For those of you who are just tuning in, good morning. We've been talking about the Recreational Land Use Act and how the Recreational Land Use Act and the Natural Resources and Environmental Protection Act exceptions for injuries to persons and property apply. And when we're talking about recreational land use, we're talking about going out and having fun, and the weather's changing. We all look forward to going out and having fun. And when we talk about the agricultural provisions of the Act, we're talking about individuals who go out and we'll call it gleaning agriculture or farm products from another person's property. Well, in the fall in Michigan, lots of people like to go to the orchards and pick apples. And they pay a fee. They go to a U-Pick to pick apples. They go to a U-Pick to pick cherries. They might go pick peaches. Depending on where they go and what their interests are, it sort of becomes a family tradition for people who like to do this, to go out every year as a family and pick their produce. The owners of the property are not responsible for injuries when you go out and you pick the produce unless you pay a fee to pick the produce. And the owners are not responsible unless there's an unreasonable risk of harm to the individuals who are out there picking fruit or vegetables, unless there's knowledge that there's an unreasonable risk of harm and something's done about it. Now, many of these same principles apply when you go out for the weekend and you go to a park and you're having a picnic and you want to hold someone responsible if one of your kids gets injured on a slide because it's an old broken down slide and it's rusty and they cut their finger, they cut their leg, or the slide breaks and they fall and get injured, or the swing breaks and they get injured. But under the Recreational Land Use Act in Michigan, they're not going to recover unless they can prove that there's neglect. And it rises to a level of neglect where there's almost gross negligence. Gross negligence meaning a willful and wanton disregard for the rights and safety of others. You have to prove that people knew that injuries were going to occur, that there was certainty that someone would be injured if the defect wasn't corrected, and you were certain that a person was going to be injured as a result of the willful neglect that occurred. Consequently, there may be a claim at that point for willful and wanton disregard for the rights and safety of others. You know, many times we hear the same stories, and nobody pays attention to these issues until after the fact. Kids go out to lakes and they go swimming. They dive in the water. No one's told them that this is not a natural pond, but they're in an artificial pond. That artificial pond was created in a rock quarry. And they left equipment down there in the rock quarry from digging in the rock quarry that could cause injuries. So the owner of the property has knowledge that somebody can get injured. And it's the failure, excuse me, to deal with that that's caused the injury. So these are some of the issues that you have to look at in order to make claims under the Recreational Land Use Act. I mean, even the simplest of activities, playing baseball in the park, playing frisbee, going to the driving range, they're all recreational activities. And all you have to do is think about how you're going to spend your summer. If you're going to go any place in Michigan where you're going to be away from your home, and you're going to be out on property where you're going to be crossing over on other people's property. I mean, if you're curious and you take a walk along the shore, the most beautiful shores in Lake Michigan, and you're going on somebody else's property, the Recreational Land Use Act is going to apply if you're injured. You know, Michigan has the second longest shoreline. If you look at all the lakes in Michigan, the Great Lakes, the inland lakes in Michigan, we have the second longest shoreline in the United States next to Alaska. So there's so many opportunities for people to be out at the beach. So many opportunities for people to be at the lake shore. So many opportunities for activities outside that it's really, really important to understand how these provisions apply. Because the worst thing that can happen is when you're out at a picnic or you're out at a family gathering, is for somebody to get injured. And all of these problems can be avoided if there's knowledge and people are willing to assess where they're going and what they're doing to avoid the injury. But you know, it's very difficult. If you're curious at all and you're walking along the shore, you're driving your car and you see an open area and you decide, you know, I'd like to go walk out there and put my feet in the water. You may be on somebody else's property and there's no liability under the Recreational Land Use Act. You may be a trespasser and there's no liability under the Recreational Land Use Act. You may decide to walk down a pier because you think it's interesting and you'd like to take your fishing pole and fish over there, but you have no permission or no right to be there. So trespassers beware, because you have no rights. The same applies to going out on trails. If there are signs that say no trespassing, those signs are there for a reason. And that is to tell you that you're not supposed to go in those areas, because trespassers have no rights on property of other individuals. And I gave you some examples of where trespassing would apply, and people would not pay attention to the fact that trespassing wouldn't apply, but for the fact that I used the ticket, like Shane Park, getting a ticket to hear a concert. If you go to the concert and you're on the concert property and you get injured and you don't have a ticket, you have no claim. So the idea is comply with the rules and you'll have no problem. Because our courts are not really helpful in this area. Our courts are not really supportive in this area because their higher duty is to protect the owners of the property. And that's the way it's always been, to protect the landowners unless there's an unreasonable risk of injury. Now, we haven't had any callers in today, so I'm going to switch gears a little bit here and talk about a few issues that have come up, and perhaps somebody might want to call in. Here's some of the calls I had last week. My son got a ticket for driving under the influence of marijuana. He pled guilty to driving under the influence of marijuana, and now he has a marijuana driving-related offense on his record. Can we get that offense off his record through expungement? The answer is no. In Michigan, any offense that occurs as a result of the operation of a motor vehicle, if it's a misdemeanor or a felony, is not expungible, cannot be removed from your record. So drivers, beware. There's no difference between driving under the influence of alcohol and driving under the influence of marijuana. Question number 2. My landlord shut off the water in my apartment, and I haven't paid my landlord rent. Can I make a claim against my landlord? The answer is yes, but you have to pay your rent into escrow. If your landlord's violating your rights and you're remaining on the premises, you must pay your rent into escrow. And if you don't pay your rent into escrow, you have no claim. Now here's the big one. Last week, my wife died, and she left her house to her daughter. This was her third marriage. We had been married for 10 years. Do I have a right to that house? Answer: if the house was deeded to the daughter before your marriage, it remains the daughter's house. If the house was deeded during your marriage, you may have a claim for an interest in the property, subject to certain rules. These issues are always coming up, and nobody's getting prepared to deal with them. We've talked about this many, many times on the air about the probate issues. We've talked about the marijuana issues many times on the air, but nobody seems to get a handle on either one of these. So please, if you have questions as to what you should do to prevent problems, give us a call at 248-335-9266. That's our office number, and get some guidance from us on what you should do to avoid a problem before the problem occurs. Don't wait until your spouse dies and you don't have a will and you haven't figured out how to dispose of property to deal with the issue. Don't wait until your child comes home and tells you that he or she has pled guilty to driving under the influence of marijuana, which also covers the passenger in the car, with the driver who's driving under the influence of marijuana, and ask for assistance in dealing with the problem. Get some preventative legal advice to avoid problems, and you'll be further ahead. Because these creeper problems are the ones that create huge obstacles and barriers for people. Now, the man who came to me about the housing issue, he's just waiting. He's waiting on a day-by-day basis. He's waiting for his stepdaughter to evict him. He says, I don't know where I'm going to go. I don't know where I'm going to live. I don't know what I'm going to do, but I'm going to be evicted. And why is that going to occur? Because there was no planning made. I asked him a simple question. Did you and your wife have a bank account? No. All of her bank accounts were with her daughter. Did you and your wife have a car together? No. Her car was titled in her name and her daughter's name. Well, if you're married for 10 years, these things should be worked out. The man said to me, am I entitled to a portion of her pension? The answer is no, because she was receiving the pension as a result of her husband's pension, and she was a widow. So when she dies, the pension goes by the wayside. You must get all of these issues lined up in an order, otherwise you won't have any benefits coming. On that note, I did have an interesting question last week. I didn't work steady for 20 years, as a man said to me, sitting across from me. But I was married for 25 years. My wife and I lived apart, and I finally got divorced. So, am I entitled to receive benefits under her Social Security? The answer was yes. Now, these are issues that may not seem important to you, but they are important on a day-by-day basis. Strange things happen. A man stopped me in the parking lot on my way into court on Thursday. I forgot about this, but this is another important issue that we've talked about on the air. And I'm bringing these to your attention because I've got time today to talk about these. Nobody's calling in. So here's the way it goes. Hey, got a minute? Well, I said, I'm walking to the courthouse. Come on, walk with me and we'll talk. He said, I'm here because I'm charged with felony child support for failure to pay child support for my children. And my ex-wife filed the complaint against me, but my children have lived with me for 60% of the time for the last 3 years. Question, did you go to the friend of the court and tell the friend of the court that your children were with you 60% of the time? No. Did your children register in school through your address or your wife's address, through my address? Okay, I said that's one thing in your favor. 2, did you provide them with clothing? Yes. Do you have receipts? I can get them. Do you have proof that your children were with you? Yes. Who transported them to school? My present wife. These are all the kinds of things that this man has to prove now in order to get over the felony child support issue. Felony child support carries with it a 5-year penalty. Felony child support also carries with problems because it can prevent you from getting a driver's license. It can cause the state of Michigan to hold up any tax refunds that you're entitled to receive because the money's going to go to the friend of the court to pay back child support obligations. Consequently, your failure to be proactive in any one of these areas can adversely impact your right to receive benefits. This is what it's all about. We're in the business of preventative law. Prevent problems from occurring by asking questions in advance and planning. Planning in advance to deal with issues to prevent them from occurring. Nobody ever takes the time to do this. And I'm not up here preaching. I'm not Dr. Holly. I'm not up here lecturing because I'm not a professor. But I'm telling you, as a lawyer of 51 years, unless you're going to prevent problems, you're going to make them for yourself, and then you're going to have a hard time getting out of the predicament that you're in. You may be evicted from a house that you've lived in for 10 years with your spouse because someone other than you owns the house. Maybe your stepdaughter or your stepson. You never know. You may not be able to drive that car that you used every day anymore after your spouse dies because it's in the name of another person and you don't know it. So get your affairs in order, and when you get your affairs in order, you're going to be further ahead in your life by doing some advanced planning. And if you're driving, by all means, please follow the rules. Do not drive under the influence of drugs, because that will adversely affect your right to maintain your driving privileges in Michigan. Well, I haven't had any calls today, so I think I'm going to call Junior over here. We're going to sign off a little early. And I'm going to invite you back next week because I've got some people that are going to be in here with some fresh new topics to talk about. So thanks for listening and have a great day and enjoy it.